Hello, everyone. Thank you all for joining us Thank you for joining us to launch the first event for NYLON Arbitration. My name is Thais Stella. I'm an associate at Mayer Brown, and I have the honor to open the event with all these amazing people around me. So we'd like to thank
I just lost her. Is she still speaking?
You're muted,
I'm muted.
or they're muted.
Oh, they're muted. Okay.
Good.
Can you hear me now?
Yes.
You can.
Oh, okay, perfect. But just one housekeeping point for everyone joining online, please make sure you're muted at all times. And if you have a question, you can just drop it in the chat. And yes, hope you enjoyed the event. I'll just pass on to Michael now.
Hi, everyone. Good afternoon, good evening. Michael Fernandez, along with the other co-founders of NYLON. It's a pleasure to greet all of you. I'm here in New York, slightly sunny, not quite sunny yet, but pleasure to be here today with all of you. And with such a distinguished set of speakers, I've seen the preview of the content that they're going to go over. It's very interesting. Very practical for those of us who have to deal with cross-border disputes and the foundational principles behind them. So we have two rock star judges, arbitrators, who are going to walk us through the differences between the two jurisdictions. And by the end of this, you're going to have hopefully a good sense of the differences between the US and the UK on issues of contract interpretation that affect our bread and butter. So thrilled to be here. Pleasure to be here with all of you, and I'm going to turn it over to Fred so he can introduce himself.
Thanks, everyone. Good afternoon, everyone. My name is Fred Singaraja. I'm a barrister practicing in England and Wales. However, I have befriended our colleagues here from New York, and together we've decided to bring you a series of events called NYLON Arbitration. So I'm very pleased that this is the first event. To everyone online, thank you very much for joining. As Michael has already said, it's a real treat to have Sir Bernard Eder and Judge Faith Hochberg with us for this inaugural event. We hope to be able to present a series of events over the course of the next year or years. We've put in an investment, so I hope it is years. And today I will be providing you with IT support. On that note, I'll hand you over to Kabir. Yes. Before I do so, let me just introduce our speakers today. So first of all, we have Sir Bernard Eder, who practiced as a barrister for almost 35 years between 1976 and 2010. So says his website, specializing in commercial litigation and international arbitration, covering a wide range of commercial disputes, including shipping, international trade, insurance and reinsurance, banking, construction, including shipbuilding, commodities and energy law. He was appointed Queen's Counsel in 1990, Recorder in 96, and Justice of the High Court in 2011. I can say that I did appear before Sir Bernard Eder on one particular occasion, and I can report quite happily that he was firm but fair. I did win, thankfully, yes, and I got costs. So thank you very much, Sir Bernard. During his practice at the English Bar, he acted as counsel in over 100 reported cases, including in the Commercial Court, Court of Appeal, House of Lords, and the Privy Council, and over 200 international arbitrations, including many on the Bermuda Form. He also acted as counsel in numerous foreign jurisdictions, including Singapore, Gibraltar, and various courts in the Caribbean, as well as arbitrator under the aegis of various institutions, including the ICC, the LCIA, and the LMAA on ad hoc basis. Turning now to Judge Hochberg. Judge Hochberg is a nationally recognized federal judge and former United States attorney, known for her broad expertise spanning judicial, federal law enforcement, and financial institution regulatory top-level positions. In 2015, Judge Hochberg retired from the bench and founded Hochberg ADR LLC, which provides mediation, arbitration, and mock court exercises in high-profile, complex matters in national and international litigation. Judge Hochberg serves as a court-appointed monitor in international cybersecurity cases, as a court-appointed special master in many cases in both federal and state courts, including complex district litigation. Judge Hochberg is a distinguished neutral admitted in the rosters of the AAA, ICDR, ICC, and CPR. She's a fellow of the College of Commercial Arbitrators and a fellow of the Chartered Institute. Her expertise broadly spans many years of law, class actions, corporate contract, insurance, banking and financial institutions, securities, antitrust, trade secrets, pharmaceutical development and licensing, patents and other intellectual property litigation and licensing, merger and acquisition transactions, and partnership disputes. Unfortunately, because their CVs are so extensive, I will not go into so much detail, but I hope that gives you a flavor. And I'll now pass on to Kabir.
Okay, now I'm Kabir Dugal. Thank you for coming. Thank you for showing up virtually. When I turn my head, I'm looking virtually at you, even though that may be creepy because you all don't know that you all are on the side to me, but that's dealing with technology. Bernard Shaw's very famous line, right? US and the UK are two countries separated by the English language. I'd probably add also separated by food, having been in England for a week. Sorry, with apologies to all the Brits. But how similar or different are we when it comes to arbitration? That's what we're looking to explore in NYLON. My first day during the master's program in the US, this was introduction to US law. The instructor comes in and tells us, in this country, we have something called contracts. Which was a little patronizing because I think every country has something called as contracts. But that's what we're going to be talking about, right? Arbitration agreements in contracts. How do we understand these contracts? Is the US and the UK the same? The US is 50 states. We are a federation like Canada. Different states tell us different things. And so we're probably going to look a little specifically at the US, looking at New York and California in particular to see whether they agree on things. And we'll add in Delaware. So for all the Brits around us, why is Delaware important? Because every company in the United States is incorporated in Delaware. There's nothing interesting there beyond that. And the fact that apparently Joe Biden's from Delaware. So we can give Delaware that. So let's begin with our discussion on contracts. And let's look at these two jurisdictions, and we're going to understand the US broadly. But what is the general approach to construction of contracts? Let's begin by looking at the United Kingdom. And then we move to the United States.
Okay, well, I start. Oh, thank you. Thank you. Good evening, and thank you very much for inviting me to speak. And I enjoy a debate with Faith Hochberg. I'd start, if I may, with a quote from Learned Hand in 1944. So I'm pinching something at the beginning from the US, where he said, "There is no surer way to misread a document than to read it literally." And that is a great quote. It comes from a case called Giuseppe and Welling, I've been told. And it may be that, in fact, on this point, England and New York or US, we're very, very similar. My own view is that the heading of this section anyway, the talk, is the death of literalism. There is a great case called the Antaios, a speech by Lord Diplock, where he said, if detailed and syntactical analysis of a word in a commercial contract is going to lead to a conclusion that flouts business common sense, it must be made to yield business common sense. Now, I quote that simply because in virtually every contract case I ever did in the commercial court as a judge, or in every case I do as an arbitrator now, where there is an issue about contractual interpretation, the antios is cited always. And that particular passage, that one sentence, is the one that comes up again and again. The other one that comes up and again is something from the speech of Lord Steyne in a case called the Sirius, where he gives the example or goes back to a moral philosopher in the 19th century called Paley, where he discusses the death of literalism. And he gives the example of a tyrant called Tenure. This is apparently true, or supposedly true. So Tenure is laid siege to a garrison called Sebastia. And he promises the garrison of Sebastia that no blood will be shed, that no blood will be shed if the people inside surrender to him. The people surrendered. He then buried them all alive, saying, I may have promised that no blood will be shed, but I have shed no blood, although I have killed you. And that is another good example why literalism is no good at all. Another good example in arbitration is where you have an arbitration clause. For example, any claim under this contract shall be referred to arbitration. Any claim under this contract shall be referred to arbitration. What does the word under mean? And for example, if you have a claim for misrepresentation, that is not a claim under the contract. So if you have a claim for misrepresentation, can that be referred to arbitration or not? And all of that was swept away in a recent case, or a case about 10 years ago. And the idea being that English law, one can use different words, purposive, contextual, all of that. But it is, I think, the death of literalism. And there is a trilogy of 3 cases in the Supreme Court called Rainy Sky, Arnold and Britton, and Wood and Capita, which laid down the general principle, which I would describe generally as the death of literalism. And I cite one last case that it's only a recent case. It was about 2 weeks ago in the Court of Appeal in England. And I cite it because it summarizes really the whole of recent authority. The Court of Appeal says it's no point in going back to early authority. How do you construe a contract? And I'm quoting now, it is a unitary process to ascertain what a reasonable person with all the background knowledge reasonably available to the parties at the time would have understood the parties to have meant. So that shows that literalism no longer exists in England, and you look at a wide canvas. Yes, Faith.
Well, thank you for that, Bernard. So very briefly, for those of you who are not from the US or have not had cases here, very quickly, we do have a dual, as Kabir said, we have laws that are both emerging and interpreted by federal courts, and we have state courts. So federal courts are courts of limited jurisdiction. They only have jurisdiction over those matters that the Congress has said they have jurisdiction over. Having said that, almost everybody prefers to be in federal court when they are in a court rather than arbitration. So they try to find a way to get within that those jurisdictional rules, and quite a number of cases do certainly find their way there. We also have state courts in 50 different states, and each state has its own laws. So while some are very similar, they are not by any means all the same. And on this question of literalism or textualism versus the death thereof, they vary. So if you're looking at US court sites, just to know where you are when you see a particular site, the federal courts, these are the constitutional courts. I sat on a federal court. The Second Circuit is the Court of Appeals for a group of federal trial courts that includes New York. So if you see Second Circuit in the site, that's a case that governs and is precedent for the states that include New York. The Third Circuit is the Court of Appeals for the states that include Delaware. I was also in a court in the Third Circuit, but I was regularly applying Second Circuit law, probably as often as I was applying Third Circuit law when I was sitting on the bench, because so many of my cases called for the application of New York law. So of the 50 states, I would venture to guess that New York and Delaware are the most commonly used in choice of law clauses that we now find in so many commercial arbitrations where I sit as an arbitrator. I think I have written more arbitral awards under New York law, and with Delaware being perhaps a close second, and far greater than any other court's law that I have applied in my 8 now plus years, doing around, I don't know, I think I'm close to 90 arbitrations. So just so you know, in New York state law, they've got a more confusing names of courts. If you see New York Court of Appeals, that's essentially the highest state court in New York. If you see New York Supreme Court, that's the basic trial level court in New York. So the Court of Appeals in New York State is higher than the Supreme Court, but federally it's the opposite, although almost nothing gets to our Supreme Court much anymore. They take very few cases a year, which is why if you see a cite to Second Circuit or Third Circuit, it's likely to be the law that will be applied in a Delaware or New York court. So having looked at it, Delaware and New York are pretty much the same when it comes to contract construction principles. Both states have a right to a jury in civil contract cases. Now, parties in the US can waive that right, but they have to both agree to that waiver or the default will be a jury case. And thinking about it, and by the way, many contracts are therefore drafted to waive a jury right if you are in litigation. And if that is correct, then, and that's in the contract, then the court will obviously adhere to that. Clearly, in arbitration, we don't have that concern. There are no juries. And I think that may account for why the New York state law and the Delaware state law appear to be as firm as they are on what they call the four corners rule than we are in arbitration, because we don't have to worry about a jury not understanding the distinction between what is the text of the contract and what is the extrinsic evidence or other evidence or drafts and comments and testimony and course of conduct that parties often put into evidence in arbitration, even when they simultaneously take the position that the contract's unambiguous. And I'll get back to that in a moment. So as I was thinking about this question of literalism versus contextualism and the continuum between the two of them, I would say New York and Delaware are closer to the literalism pole, and California and certain other Western states are closer to the contextualism pole. But while they voice those rules, there are many ways in which a certain degree of context definitely gets into it. And I should say, Bernard, that Bernard, excuse me, he did correct me on the pronunciation. I'm trying very hard to adhere to the British version of that name. I was the research assistant for a constitutional law professor while I was in law school, who wrote the definitive biography of Learned Hand. So I was reading a lot of his original papers way, way, way back then. An amazing man, as we all know, and one whose name is still hallowed in the halls of US courts. New York follows the four corners rule of contract interpretation. And you can find a myriad cases that will have quotes such as the following: the reviewing court must confine itself to the four corners of the document and only consider extrinsic proof if the contract is ambiguous. If the contract is not ambiguous, it must be enforced according to the plain meaning of its terms. Now that sounds like it is literalism, but there are when you hear the word context, you will hear it, but you'll hear it as to say the context. You cannot just look at those words. You have to look at them in the context of the entirety of the contract. You can't go outside the contract, but you can consider them within the entirety of the contract, including the business in which the two contracting parties are in and have contracted. So that does give you leeway to sort of construe words such as under, if there are other things in the contract that would lead you to believe that it means arising or related to, which is not under, but may nonetheless be deemed to be within that arbitration clause, depending on who's reviewing it. And by the way, in the US, the courts have the ultimate authority to determine whether an issue is arbitrable and subject to the jurisdiction of the arbitrators, unless the clause gives a clear and unmistakable grant of that authority to the arbitrators themselves to decide. We're not on that topic today, and much ink has been spilled on that issue and much discussion of it in arbitration conferences in the US, but I'll stay off it for now. So as recently as 2010, the Second Circuit, which as I've said is essentially the highest authority for federal courts that are construing state New York law, wrote, quote, "A written agreement that is clear, complete, and unambiguous on its face must be interpreted according to the plain meaning of its terms and without the aid of extrinsic evidence." But then they go on to say, and this is a little bit of an out, which gets them not right at the pole of literalism. They're somewhere in the middle, but not, I would say, at the halfway mark. They say things like a fundamental tenet of the contract law is that agreements are to be construed in accordance with the, and this is the word, intent of the parties. So they're going, okay, maybe we can look at intent, but then they pull it back and say, and the best evidence of such intent is what is expressed in their written agreement. So rather, they look at the entire context of the contract. They will take cognizance of the nature of the business that the parties are contracting in. And when the contract includes, it's between a business and a member of the public, or a very unsophisticated business, or an individual investor, the rules will be somewhat relaxed in both New York and Delaware, and they will then come closer to what Berna just described as the objective test of what would a reasonably intelligent person in the position of the counterparty to that contract ordinarily expect that contract to mean. And I will stop there and turn it back over to you.
Thank you. Thank you both for that. Okay, so we see the death of literalism in the UK. We see the four corners rule with this exception in the United States, well, in New York and Delaware at least. Let me present the next question. If there is ambiguity, to what extent, if at all, can you go beyond the contract? Can you look at the drafting history? In other words, the parole evidence rule. Can the courts in these jurisdictions consider that? Perhaps this time, Judge Hochberg, you want to go first, and then we'll pass it to you.
Okay, that's fine, sure. So the courts have also defined ambiguity because, as Kabir just said, if a contract is deemed to be ambiguous, then the parole evidence rule does not apply and extrinsic evidence can come in freely. The definition of ambiguity, you'll find it in many places, but it always comes down to pretty much the following. And ambiguity exists where the terms of the contract could suggest more than one meaning when viewed objectively by a reasonably intelligent person who has examined the context, of the entire integrated agreement and who is cognizant of the customs, practices, usages, and terminology as generally understood in the particular trade or business. So that's a pretty long definition with a lot of moving parts for when a contract is or is not ambiguous. And then the New York courts go on to say that to determine whether or not a contract is ambiguous, the contract must, as I said before, be read as a whole in order to determine its purpose and intent, and single clauses cannot be construed by taking them out of their context and giving them an interpretation apart from the contract of which they are a part. So with that, I would add, for a touch of at least what I always find mildly humorous, with my arbitration and my arbitrator hat on, which has been on now firmly for over 8 years, it is very common that copious amounts of extrinsic evidence come in from both sides without any objection by either party to the proffer of extrinsic evidence by the other party in a contract interpretation case that is governed by New York law or Delaware law. And when I ask the attorneys, does either of you argue that the contract is ambiguous? And they both say, oh no, it is unambiguous as long as you read it my way. And then the other one will say the same thing. And the reality is that in arbitration, regardless of this very interesting topic we're discussing, the principals trust the arbitrators to understand the difference between the terms of the contract and extrinsic evidence. And almost all of the time it comes in because the parties submit it without any objection. And in fact, the rules of evidence don't apply to arbitrations for the most part, or the ones that do apply in the courts. And it is a fertile topic, again, for arbitration consultants, whether the parole evidence rule is a rule of evidence, in which case it has no bearing in arbitration, or whether it is a substantive law of those states that hew most closely to it. So if a contract is found to be ambiguous and extrinsic evidence comes in, the most common types of evidence that come in are evidence of course of dealings and of drafts. Those, at least, other than just the written communications or testimony of a witness, those would generally be the kinds of evidence that was done at the time when the parties were performing under the contract. And so before there was any litigation, they are the ones most commonly chosen by the parties to be introduced. Yes, you do get a lot of witnesses testifying as well about what it was and what happened and who said what to whom. But the contemporaneous evidence at the time generally comes in and generally is considered more powerful. One a finer point on that is that it is important to remember that whether it's in arbitration or otherwise, internal communications within a company that are, or thoughts in the head of a drafter, are not evidence of any intent by the parties under New York law or Delaware law, unless there is evidence showing that those thoughts and positions were clearly communicated to the other party. One-sided evidence of intent is not probative of mutual intent. That's a quote you see often in New York cases. Or as the Second Circuit held in 2006, a party's intent that is not communicated to the other party has no bearing. Only the intent indicated by words and acts made known to the other party may be considered. And a witness's own understanding that are not communicated to another party cannot change the meaning of statements and acts that are communicated to that other party. So I will hand it over to Bernard.
I think there's great similarity. We may use different language, but there is some great similarity. You mentioned ambiguity, and one person's certainty is another person's ambiguity often. I mean, there's a great case, go back to the Antilles just for a moment. That was broadly, it was a charter party case where the ship owner was entitled to withdraw the vessel for any breach of contract by the charterer, any breach of contract by the charterer. And I'm simplifying it and maybe not exact, but that's sufficient for present purposes. And the question was, what does any breach mean? And in a way, the language is clear. It means, I mean, the word any, if you look up the dictionary, it's as broad as you can have it. Held by the House of Lords that any does not mean any. It means only, in effect, a repudiatory breach. So it's not any breach, it's repudiatory breach. Now, I mention that simply because that is one of the best examples, I think, of the clash between what one might think is clear and what the courts construe otherwise. So that's a big question mark on what is ambiguous. Turning to the parallel evidence or extrinsic evidence, I think we agree in England on two things. First of all, subjective intent of one party is irrelevant, completely irrelevant. Again, it's similar, we use different language, I think, but evidence that we say crosses the line between A and B, between the counterparties, may be relevant. We'll come back to that, but it's got to cross the line, or possibly, we'll come to this, be reasonably available to both parties. So that's subjective intent. Secondly, there's a complete bar on negotiations. So negotiations between parties is, I'm going to say, generally irrelevant. So if there's a draft that goes across to the other side with a clause in, or a paragraph in, or a wording in, or a phrase in, the other party then strikes that out. And then there is a dispute later on about the meaning of the words that are left. Is it permissible to look at the negotiating history to decide what is left? Now, that is, I'm going to say, negotiations are generally, it's a lawyer's answer, generally excluded, and you can't admit those. A more difficult question is whether, if you have a standard form contract and a clause is stricken from the contract, are you able to look at that to determine what is left in the contract? I'm not going to give an answer to that rather difficult question. But everything came to a pitch in England anyway, in a case called ICS and West Bromwich, where Lord Hoffman held that what was admissible in that case, and I'm quoting now, what was admissible, what was known or reasonably available to both parties at the time of contracting. So what was known or reasonably available to both parties at the time of contracting. Now that caused a complete storm in England, is the truth. I was practicing at the time, but broadly speaking, and that's now shortened into what's been called factual matrix. Factual matrix is effectively a shorthand for what Lord Hoffman held, what was known or reasonably available for both parties at the time of contracting. That has been brought back a little, and there are different views about that. What is clear, though, and this is very, very important, I think, is that in the commercial court and in every arbitration I do, there is a requirement, in the commercial court, there is a rule that says that any party who wants to rely on extrinsic evidence in support of the true construction of the contract has to plead it. You have to plead it specifically. And that is a rule. And in arbitration, I put that into I think all of my procedural orders, so that you know in advance of the service of witness statements, you know in advance of the case exactly, specifically, what each party may say might be admissible in terms of the construction of the contract. Otherwise, you get to a hearing and you have endless witness statements talking perhaps about negotiations, about a whole range of other things, which renders the whole hearing appalling. So in England, that is the rule. No subjective intent, no negotiations, admissible about what was known or reasonably available to both parties, and you have to plead it. I'm talking about the court at the moment. Separately from arbitration, let's just deal with arbitration. There is a great question about, like in New York, as to whether or not an arbitration governed by English law, whether an arbitrator is bound by laws of evidence. And that's too broad a question, I'm afraid, to deal with now. So anyway, those are my views on that. Thank you.
So I have a question for Bernard. Two questions, actually. So let me go in reverse order. Can you amend the pleadings at a later date to add the extrinsic evidence that must be pled, or is there a cutoff point when the time of the witness statements comes in?
The short answer is there is never a cutoff point. You would have to apply for permission to the judge, and the judge may or may not agree. Normally, the court would look at questions, for example, of prejudice, the time prejudice is usually the big question. The court would also look at costs, whether, for example, if someone wanted suddenly to adduce evidence of factual matrix at a late stage, whether the other party had sufficient notice of that to deal with that or not. But the short answer is, I say never say never. You can always do it subject to those questions of prejudice and cost broadly.
And in reality, in arbitrations, is the same test applied when a party wants to amend its arbitration pleadings to add?
Yes, broadly speaking, yes. I'm not sure how many people put this in, but arbitration, there's no doubt it's much more lax, it's laxer. But the two questions about prejudice and costs are usually the two guiding factors that decide whether or not to give leave. I mean, I've had cases virtually in the middle of a case, someone wants to do that.
Okay, the second question I have relates to one of the earlier.
That was the second question.
No, that was I'm sorry, then it's the third question. I'm asking leave to ask a third question. And this is my question. I see a significant difference between this bar on negotiations in England and in the US, where it is not at all uncommon, if extrinsic evidence comes in, for there to be drafts of contracts. So let me ask you, in England, let's suppose there is a contract that's going back and forth with the usual comment boxes that you see and red lines and strikeouts that go back and forth between the parties. If there is a provision that is struck out, and then that party later wants to say, but that's what the parties meant all along, are you saying that the other side cannot show the evidence that they struck out the very thing they're now claiming was in there all along?
I'm going to say yes.
Interesting. Now, I don't think that would be the case in the US once extrinsic evidence comes in. I see many very learned, probably more learned than I am, colleagues from the New York arbitration world who may disagree with me, but I would be surprised.
Whether that would apply in arbitration is different. I mean, arbitration is much, much different.
Fair enough. And it is definitely true. Right.
Even a contract governed by English law determined in arbitration, the position would be at least potentially be very different.
Okay, so with the, sorry, and for that point of privilege of asking him questions, my apologies to the moderator.
No, those are great. Please keep doing that. Okay, next question. This is our contract. Okay, so this is our document. We have put in the words. Right now, it's only legible to me. To what extent can we imply terms into this document we have drafted? We'll hear the UK and then we'll come to the US this time.
Okay. Well, English law going back a long way was absolutely clear. And that is, when you construe a contract, it had effectively two stages in it. One is you construe it. And secondly, whether or not you can imply a term was in effect, a separate exercise. And English law, there were various tests. I'm not going to go through them all, but broadly speaking, there were three requirements before you could imply a term. Let's see if I can remember them. Three requirements. The first is the implied term must not be inconsistent with an express term. So that's the first requirement. The second requirement is that it must be, and the test is the various different words, but I like the test of it must be necessary to make the contract work. And the test of necessity was absolutely, let's say, essential, necessary. It had to do that. And the third was rather more open textured, which I needn't go into. But so that was the traditional point. And then there was a case in England in 2009 called Belize, which was a case, in fact, on Privy Council, where Lord Hoffman effectively decided, and I'm summarizing it, and I hope I'm summarizing it fairly, and that is, he said, that is a wrong approach. That the question or not whether there is an implied term is really part and parcel of the exercise of construction of the contract. So the two were really part and parcel of the same exercise. And that caused, again, some consternation. It was controversial in a way. Interestingly, that was in 2009. Interestingly, in Singapore, where I sit as a judge from time to time, in a case in the Court of Appeal there, rejected that approach and said, no, that isn't right. And then later, in an English case, Marks and Spencer's 2015, the Supreme Court has rowed back from what Lord Hoffman said and said that in effect, I don't want to overstate it, but in effect, the question of whether or not there is an implied term still depends upon the necessary test, the necessity test. So I think it's fair to say that English law does not like implied terms. I still think that's the right approach. And that unless a term is necessary to make the contract work, then the conclusion is there is no implied term. The problem is that if you start implying terms, what you're really doing is you're rewriting the contract. And English law says, if it says anything at all, the job of the court is not to rewrite the contract.
So on that, Bernard, we are, I think, even though we are separated by a language, for sure, I think the likelihood is that if you and I examined, let's say, 10 cases where a party sought to have an implied contract term, I don't think the approach of the US court in New York would differ from the English court. So my answer to when does a court find an implied contract term is in New York, the short answer is quite rarely, but not never. And what I've done is I've boiled down a lot of quotes from cases. I'm not going to bore you with the names. I don't even have them in my short form notes here. But these are the kinds of things that courts in New York say. They say, for example, courts should be extremely reluctant to interpret an agreement as impliedly stating something which the parties have neglected to specifically include, especially in commercial contracts negotiated at arm's length by sophisticated, counseled business people. A court should not imply a contract term which the parties themselves fail to include. So that's the two sophisticated business entities negotiate. Other courts have said things such as, in the absence of fraud, negligence, or bad faith alleged or established, the court has no duty to read into contracts conditions or limitations which the parties have not assumed. Another one says it as follows: a court will not imply a contractual term where the circumstances surrounding the formation of the contract indicate that the parties, when the contract was made, must have foreseen the contingency at issue and the agreement can be enforced according to its terms. And finally, they say exactly what you just said a moment ago, Bernard, where when the expressed intent of the parties, the contracting parties, is clear, a contrary intent will never be created by implication. So when you leave the commercial arm's length sophisticated party negotiation, and the contract involves a counterparty that is an individual consumer or an investor, you'll find more laxity in implying an obligation. And courts say the same thing that the necessity test seems to say under English law, which is that an obligation may be implied and enforced if it is a necessary implication from the provisions of the contract. So I'm not even saying that that would necessarily not be done if it was two sophisticated businesses. In other words, if it was impossible for the intent of the contract to be carried out without some term being that was necessary to it being implied, it's not impossible that a New York court, even in a business context, would find that term to be implied. So as a corollary, I think this is part of the corollary of the courts often saying in construction that you have to consider the whole contract and not just a particular clause. And I think that they're closely related in that way to construction. You look at the whole contract to determine what the party's stated intention was. And if it's missing a term that nobody said was not going to be there, then it may be implied. The rubric that the courts use in those circumstances is that, quote, the contract includes any promises which a reasonable person in the position of the promisee would be justified in understanding were included. And in Delaware, they often say the same thing about an investor. If it's a promise that a reasonable investor objectively would have thought was there, then they may well enforce it as being there, even if not expressly stated. So I don't think the two countries are that far apart on this issue.
Thank you, Judge. So talking about agreements, hopefully we are moving to one where there might be disagreements if we're expecting drama. That's always fun. To what extent does good faith play a role in construing contracts? Let's begin with New York, Delaware, the United States, and then let's hear the UK. And we want drama.
Drama. Okay. So in New York and Delaware and New Jersey and a vast number and many other states, I can't say everyone because I have not looked at the 50 state laws on this. There are sometimes even expressed into law that every contract implies a good faith and fair dealing of the parties to it. And they also find that includes a duty of cooperation between the parties that is implied in every contract. So this is how New York law expresses it. And I'm, again, rather than focusing on a single case, taking certain quotes out of the cases, but you'll find many, many quotes on this. So as recently as 2017, under New York law, all contracts imply a covenant of good faith and fair dealing in the course of performance. Encompassed within the implied obligation of each promisor to exercise good faith are any promises which a reasonable person in the position of the promisee would be justified in the understanding were included. And then another one from New York State Court, the implied covenant is a pledge, I'm now reading a quote, a pledge that neither party shall do anything which will have the effect of destroying or injuring the right of the other party to receive the fruits of the contract, unquote. So the claimant has to be able to show by a preponderance of the evidence that a party to a contract acts in a manner that, although not perhaps expressly forbidden by any contractual provision, would, and this is often the language used, deprive the other party of the right to receive their benefits under their agreement. And that language is repeated many times in many different cases. One thing I would add is an oft overlooked wrinkle under New York law, which is not very well known. But there are a number of cases that so state that a claim for a breach of a covenant of good faith and fair dealing cannot also be pled and would be deemed duplicative when a breach of contract claim is pled on the very same facts, or where the conduct at issue is also the predicate for breach of the underlying contract. It's not quite as bald as that language. What they look to are various factors in deciding whether the good faith and fair dealing claim is to be dismissed as duplicative of a breach claim, but they look at things such as the relatedness of the damages sought in each claim. So a plaintiff, though some of the courts say, can pursue both claims, even if the damages are identical or intrinsically tied together, if the two claims involve different underlying factual allegations. So Delaware law has the same, quite substantially similar types of language. And I realize that this is NYLON and we're to be looking at New York law only, but so many of you likely have arbitration clauses that include Delaware law that I have thrown it in where it seems to be appropriate and can be stated fairly quickly. It basically says that public policy mandates, this is from a Delaware Supreme Court case in 2005, a state case. Public policy mandates that we recognize an implied covenant of good faith and fair dealing in every contract governed by Delaware law, which, quote, requires a party in a contractual relationship to refrain for arbitrary or unreasonable conduct that has the effect of preventing the other party to the contract from receiving the fruits of the bargain, unquote. So it also has an implied covenant that requires that discretion be used reasonably and in good faith. That's also under Delaware law. And Delaware is not considered a liberal state. It's a very business-friendly state on this. So I would say in this case that Bernard's tyrant in Sebastian would have violated the covenant of good faith and fair dealing, despite the literalism issue, because one would say that the people inside the garrison would reasonably have believed that their lives would be spared, regardless of whether they died via blood or via suffocation. Bernard, over to you.
I think we agree about the tyrant, but I mean, this is one area I'm afraid where we completely, I think, disagree, Faith, if I've understood you correctly. In England, I'd say at the moment, it's controversial, and I'll come to that in a moment. It may change in the future, but as things stand at the moment, there is no general obligation of good faith in any contract or most contracts. There are specialist contracts of certain types, personal contract, put those on one side. I'm looking at business contract for a moment. There is no general obligation of good faith or fair dealing in England at all. There was a judge at first instance, Mr. Justice Leggett, who suggested that there might be. That was rejected by the Court of Appeal a few years ago, and that is the consistent approach of English law. I say, why is it controversial, is because Mr. Justice Leggett, at first instance in this case that I just mentioned, who was overruled, is now one of the judges in the Supreme Court in England. We'll have to wait and see what may happen in the future. Having said that, the English law approaches the kind of difficulties of unfairness and people acting contrary to good faith in a piecemeal way. And Lord Justice Bingham said that the right approach is in a case called Interphoto, but also in the more recent case I mentioned, is that the English law adopts a piecemeal solution in respect of demonstrated problems of unfairness. So English law will deal with questions of that kind, not by way of reference to good faith or unfair dealing. It will do it, if at all, by reference to, for example, implied terms. Of course, I put on one side as well cases where you have express obligations of cooperation and that kind of thing. I'm not talking about those. But I always like to test the question of good faith, where a party has an option to terminate in certain cases. So, for example, again, let me take a shipping case. A ship owner has an entitlement to bring the contract, the charter, to an end if the hire isn't paid by midnight on the 1st of June. Clear clause in the contract, an option to terminate if hire is not paid by midnight on the 1st of June. The hire is not paid on the 1st of June. Let's assume that there is a banking error or someone just forgot. And let's assume as well that the reason why the owner then terminates is because the market has gone up and the owner wants to benefit hugely by getting out of a 10-year contract and being able to earn a lot more money on the side. So 1 minute past the midnight, the owner terminates. Can it be said that that owner is acting in bad faith or contrary to fair dealing by taking advantage of the non-payment by 1 minute in a long 10-year contract? And the short answer is yes, he can, because the fact that the market's gone up is irrelevant. The fact that the payment is late by 1 minute is of no real concern to anyone. The short answer is that's what the contract provides. And if that's what the contract provides, it's not to be watered down by any concept of fair dealing or acting in bad faith or anything of that kind. So my own view is, in England, there is no general obligation of good faith or co-op or fair dealing. English law does deal with problems of unfairness in different ways, more specific, and it's typical of English law about dealing with it on the basis of a problem, dealing with problems as they arise. So maybe English law and New York law, Delaware are different in that.
So go ahead. I'm sorry, I didn't mean to.
How would you decide the 1 minute point?
So I was about to say that in the US, that's too broad because I haven't looked at every state. And I think everyone knows that we have some states that are enacting some really weird laws these days. But let's say New York or Delaware. I don't think that the fact that the ship owner terminated the minute he was allowed to do so because the market rose would be deemed to be bad faith or unfair dealing. However, if there was any evidence that the ship owner either had done something to cause the lateness of the payment or had lulled the other side into believing that a couple of days wouldn't matter or a few hours wouldn't matter by an email or a phone call, or had some control over the intermediary causing the payment to be made from the hirer's bank or financial system to the ship owner's bank or financial institution or something of that sort, then you would have a serious issue.
But can I interrupt you rudely, Faith? I agree with those examples. I mean, the way English law would do it, they would say, right, there's an estoppel of some kind.
Mhm.
Or there is a general doctrine that if one party, in certain circumstances anyway, actively prevents the other party from performing that party's obligation, then there'll be certain consequences in that sense. But English law does that. The important point is English law reaches perhaps the same conclusions as in America, as in New York, not by any general doctrine of good faith or fair dealing, but by specific conclusions with regard to obligations, so prevention, estoppel, or misrepresentation, something of that kind. It's much, much more granular, and we reject any general concept of good faith. That's pretty clear.
So that is a big difference, because otherwise it would be interesting to chart the fact patterns of a series of cases on both sides of the pond to see if the results actually would be different under the other side's application of the principles. Because I think to some extent, even though, for example, New York is a four corners jurisdiction, they use other ways to include a little bit of contextualism into it, even though they eschew it as a principle. So it'd be interesting. Do you have off the top of your head any examples of something you would consider a grossly unfair result that was allowed to stand in an English court? And if that's taking us over the time limit, let me know, Kabir, and I will withdraw the question.
No, I mean, my example of a ship of a charterer who pays hire 1 minute late would be regarded, I think, in many jurisdictions as of itself. Forget about an estoppel, forget about anything else, forget about any exchange, just simply where the charterer pays 1 minute late. Let me explain, to emphasize, due to I'm going to say, a fault, for example, in the banking system, it just took longer, whatever. In those circumstances where there is no fault on the part of the ship owner, but simply the money comes in late. That might, in many jurisdictions, that would be regarded as unfair, and that if the ship owner withdrew the ship simply in a long-term tenure charter, simply to enable the ship owner to earn more money, would be regarded as unfair and contrary to fair dealings. And I'm giving, I'm not sure, absurd example where the payment is just 1 minute late. And it would be regarded in many jurisdictions as preventing the ship owner from being able to exercise.
And I think that might be a very close call, and that result might very well be different in New York or Delaware, where essentially the court might imply a provision that is, if the all actions appropriate and necessary had been taken by the payor, and through no fault of the payor, there was a glitch in the banking system. I think that would be a very close call on how that case would come out. I see we have a question. Kabir or Fred, do you want to ask it, or shall I? I see Mike Lampert has a question.
Sure. Thank you, Mike. So the question is, how does the English lack of a general good faith in commercial contracts square with the implied duty of, I think it's mutual trust and confidence in employment contracts?
Employment contracts are completely different, and I'm not an employment lawyer. That's a good lawyer's answer. But I'm not an employment lawyer. I'm looking at business contracts generally, and employment law is governed by a whole lot of separate principles. I have a very good friend. We have a program in England called Do You Want to Be a Millionaire? I think it is, where I've got an option of phoning a friend, I think, to answer a question. So I'd like to phone a friend on that one. Thank you.
I think that program actually originated in the US, although I'm not 100% sure. And I think, Mike, I've noticed that a lot of, as I was doing some reading for this program, looking at a variety of sources, there tended to be several times where in US law I would find an exception or some slightly different take on employment contracts. And I didn't dig into that well enough to know, and I certainly have no idea about England. I thought, and perhaps I'm wrong, that it's generally believed to be harder to let somebody go in Europe than it is in the US. Am I wrong on that?
We're being told it started in the UK.
You're wrong.
I'm wrong. Okay, I accept defeat.
I'm told.
Okay.
I think we're heading to close, aren't we? Is that right?
Yes, we'll see if anyone in the room, virtual or here, has a question to all this. Okay. I was just trying to motivate people.
Hi, Jessica Splendorio. I had a question, I think, on a point that Judge Hochberg picked up on the intent of the parties and negotiations history. As a New York lawyer, when you're in either a litigation or arbitration, sometimes the drafting history, especially the negotiations and the term sheets, really do come in because there is true ambiguity. Now, I know as Sir Bernard said, it could be different under English law, but I'm curious to hear, when would that come in under English law, especially when that's the only evidence that can really demonstrate what the parties intended? And I'm speaking from experience. I'll give you an example without parties, but when you're in a licensing dispute and you're looking about the term, for example, of what a patent term means, that turns on whether or not royalties are paid. And the only evidence of what that was meant to encompass, or the broadness of that clause, can only be found in the term sheets or the drafting history and the negotiations. So I'm curious to hear how that may turn out differently, maybe in an arbitration under English law versus New York.
Well, two things, first of all. Let me put on one side any claim for misrepresentation, because obviously, if there is a claim for misrepresentation, then you can look at anything virtually, completely. So far as negotiations are concerned, there is I'm going to say, I never like to say never, but there is a general bar on negotiations, because parties will have their own views as to why they included something or didn't include something. There are some authorities, and let me just say, let me say it this way, the line between negotiations and factual matrix, in fact, can sometimes be very, very thin indeed. That is important. And many cases I have done, people try to adduce evidence about factual matrix, but in truth, they are negotiations. And there is a fine line. And I think there is a recent case that in the Court of Appeal, the trouble was, it was a case about when in England we have something called summary judgment, where someone tried to apply for summary judgment as to the meaning of a contract. And the Court of Appeal rejected the application for summary judgment on the basis, and some might say surprising, that they said it may be that negotiations may assist in explaining the meaning of the contract, may assist. So it's all very tentative at the moment. But I cannot at the moment think of any case where true negotiations have been admitted to assist in the construction of a written contract that I can remember. Again, I'm not a licensing lawyer, and it may be special rules apply there. So I don't know about that.
Let's take one more question. Anyone in the room? We'd love to hear what Canada has to say on good faith too, but.
Do we have Canadians that want to speak up? I'd be curious to know too.
Just Barry, but that's Barry Leon. I'm not
I don't
going
want
to
to put my friend Barry on the spot.
yeah, well, there is the Supreme Court of Canada decision on good faith, which basically is too complicated to explain now, but the door has slightly open in a certain way. So it's not worth taking the time to try to explain it without more preparation. But what I was going to ask, I was reading something this morning, and I can't remember where or why, but on the difference between transactional contracts and relationship contracts, commercial contracts. And do either system, the English system or the New York American law, make any distinction when it comes to the areas we've been talking about?
So Barry, what's the two transactional contracts and relationship contracts?
Buying and selling a piece of property or an item is a transaction. A long-term contract to build something, to develop exploit a patent together, to do something together, develop a product together would be the relationship.
Oh, that's a very interesting question. I hadn't thought of it that way, and I'll have to go back and reread. I haven't noticed in the cases I've read any divergence in the cases, the decisions based on that. I'm trying to think it through. I mean, obviously one is very concrete and the other is ongoing. I would guess that you'd have far more extrinsic evidence, obviously, in the ongoing relationship type of case. But But I don't know that I haven't seen cases that decided differently after they analyze what type of transaction is at issue. I could call on some of my US colleagues whose faces I see on the screen, but I don't want to put them on the spot. We may have some who have a better answer than I do on that.
Well, let me interrupt. And English law certainly does make a distinction between the terminology varies, but between transactional and relational. There is certainly a difference there. I'm trying to remember. I can't remember, I'm afraid, the name of the case. And relational is quite a different. How far does it go? So if you start off, for example, with an employment contract, that is the archetypal relation type of contract. You then go further away from that between a principal and agent in a way that is also relational as well. But it can go further than that, and that's what I'm not sure about. But certainly in England, there is a great difference between, I'm going to call it transactional or ordinary business contract and other types of contract. Yeah.
So do you think the covenant of good faith would apply more strongly in a relational contract?
I would want to look at that, Faith, as the truth. But the short answer is yes.
It's interesting. I mean, I do lots of licensing cases, but I haven't seen that issue raised about in any briefing that where one party has responded to another party's points on it.
The other way that English, again, I would want to, I mean, it's a seminar on it, but another way of doing it is that the concept of implied term, what terms can be implied, would be much easier, I think, in a relation type contract.
And you'd have lots more, of course, of dealing extrinsic evidence as well. So in an arbitration, you'd certainly have all that coming in, which it usually does.
And what would the answer be in Canada?
I don't know.
Okay. There is no answer in Canada, is the answer. Just Elsa, any idea? Fair enough. Okay, with that, let me pass it to Thais.
Thank you all for joining, especially those virtually and our panelists. And for those lucky enough to be here in person, we have drinks being served in the back. Please join us.
I expect a drink to be sent to me by FedEx.
Thank you, George.
Thank you, everybody. I really appreciate it. Bernard, I'm
Thanks,
looking
everyone.
forward to meeting you in person. Take care.
Take care.